and welcome to Epstein Becker Green's webinar, Data's Impact on Employers. I'm Schaefer. I'm a partner in the New York office of EBG, and I'm a co-leader of the Tech Media Telecom Service Team. I'm going to be joined today by 5 fantastic colleagues, my partners Adam Forman, Nathaniel Glass, and Michelle Capezza, and my associates Nancy Gunzenhauser-Popper and Alyssa Muñoz. It's not very often you get to quote an iconic 1980s movie in an employment law webinar, but today is the exception. As Becker famously pronounced in the movie Wall Street, the most valuable commodity is information. And words have perhaps never rung truer than in today's world and in our today's workplaces. As we know, modern employers have access to an unprecedented amount of information or data impacting its workforce, from data concerning the trends and patterns in employee behavior, data concerning people analytics used in hiring and compensation and in benefits, to data analyze and dissect the composition of the employee workforce itself. And for employers, this presents numerous challenges and opportunities, particularly in an employment age focused on increasing demand for transparency from employees, from regulators, from shareholders, and the general public. And so these two competing phenomena, the availability of big data and the need to use big data responsibly, present an important question. How can employers best leverage the power and information of data while mitigating organizational and reputational risk? That's what we're going to be covering today. We're going to cover a few key areas: big data analytics and hiring, building benefit plans, cybersecurity policies, equity audits. That's our agenda. A few housekeeping rules before we begin. Please be advised that today's webinar is being recorded. Participants will be placed on mute throughout the program, so if you have questions, feel free to submit them throughout the program by using the Q&A feature provided on WebEx. At the end of the program, with time permitting, the speakers will address your questions. You're also welcome to submit questions directly to the presenters following the webinar. Speakers' contact information will be displayed at the end of the presentation, so feel free to reach out directly to them. In approximately 2 to 3 business days following the webinar, we'll communicate the availability of the webinar and the PowerPoint through a link and an email communication, so please be on the lookout for that. At this time, without further ado, I'd like to turn the webinar over to my partners Adam Forman and Nathaniel Glass to discuss big data analytics in hiring.
Big analytics is in the news almost daily. It's being used from everything from figuring out how people will vote, to what flavor ice cream they'll buy, to, of course, workplace decisions. Our time during this webinar, Nathaniel and I are going to provide a somewhat high-level overview of how big data is being used by employers to source candidates for employment. Our goal is not to hit every point, but to red flag or identify, highlight issues that you want to be thinking about as an organization if you are either using big data for sourcing candidates or you're considering using big data to source candidates.
We'll pivot to some of the legal risks associated with using big data for recruiting and hiring, and identify some practical considerations and provide you with our thoughts on some of the main points to review when deciding whether to use and how to implement big data in acquiring talent for your organization.
Start with just kind of level the playing field. I thought it was important to identify what big data actually is. And as you may expect, there's not one definitive uniform definition everyone agrees on as big data. We've provided for you the definition from Oxford English Dictionary as well as Wikipedia. But a good way to think about it is big data is a broad term that often encompasses the volume of data, the rate at which the data is collected, the type of data being collected, and of course how best to cipher that data. You can think of it as a synonym for both the actual data itself and necessarily computerized analysis of that data. There are many acquisition platforms in today's marketplace that utilize big data for sourcing or acquiring candidates. Many of the options provide more than just recruiting services. HireView is an example of one product out there that allows employers to conduct all of their interviewing and hiring in an online format. Moreover, it provides prospective employees with the convenience of video recording their responses to predetermined interview questions whenever and where they want. Another popular product on the marketplace today is called Textio, T-E-X-T-I-O. Textio describes itself as a, quote, augmented writing platform for creating highly effective job posts, end quote. By analyzing the hiring outcomes of more than 10 million monthly job posts, Textio predicts the performance of its clients' job posts and provides feedback on how to improve it. Textio claims that those who use its products recruit 23% more women. There are lots of other popular solutions out there, Koru, Biometrics, Google Hire, Assessment, and many others. So where are these service providers procuring the data that they're using in helping employers acquire talent? Well, it's really three sources. First, they're looking at publicly available data. It is amazing how much information is out there which is publicly available about each and every one of us. Service providers use sophisticated algorithms to scrape this data from these publicly available sources to create a picture or profile with the goal of helping employers make the best, most efficient, and effective hiring decision. Another primary source of this information is information that's provided by the applicant, him or herself. Quite a bit of it comes by way of the resume or the applicant from the application of the applicant. The final category where this information is derived is employer-stored data. For example, companies collect data on current employees' job performance every single day they've worked on the company clock and combine that with the results of employment tests and macroeconomic trends on job growth or population shifts. Software algorithms then will identify meaningful patterns that can be used to assess potential new hires. Applicants in turn are given a score indicating whether the company should move forward based on a myriad of factors, including career history and personality testing.
Schaefer back in New York. I understand there's some technical difficulties with some of my colleagues, so please bear with us for just a moment and we'll get them on the line.
No, I'm sorry about that. As Adam alluded to, big data analytics can be used for hiring in a variety of ways, and the vendors specializing in big data analytics offer a variety of tools for companies looking to utilize this information for hiring purposes. The tools that they offer run the gamut from promising better job posts to lure the best candidates to your site, to scraping LinkedIn or other available online data to find the best matches between your open position requisitions and available candidates out there, or people who aren't actively looking but might be interested in looking at your job. There are other tools that automate screening interviews so that it can be all be the same initial interview questions, and some of the tools will even evaluate the responses to those questions for you. And even others offer cognitive assessments of candidates to see if their skill sets are a good fit for your open position. But the key to all of these analytical tools is that they all promise to be more predictive of good candidates than traditional hiring procedures. They will suggest that they can identify candidates that not only will be the best fit for the job, but will stay there longer than your typical candidate. companies that first turn big data analytics to do so in hiring because they expect to benefit from a faster, more efficient recruiting process, which should cost them less. They can divert their other personnel to more human resources related functions and automate much of the screening process. In addition, the hope I said earlier is that these tools will lead to better job matches. The predictive power of the algorithm will hopefully find the right person for the job whose skill sets are a better match and who will stay longer there. In addition, big data analytics also promises the use of neutral hiring criteria, which means an increased objectivity and reduced subjectivity in the decision-making process. And the expectation is basically that by reducing subjectivity, that will reduce the likelihood of a disparate treatment intentional discrimination claim. Another point to mention here is that record-keeping requirements may be reduced for employers that utilize big data analytics. Contractors, federal contractors, are required to solicit race, ethnicity, and gender data from all individuals who are deemed applicants for employment, and those records generally must be kept for 2 to 3 years. The larger the pool of applicants, the larger amount of data that a federal contractor must retain. Using big data analytic techniques, you may be able to source individuals without becoming applicants under the Internet Applicant Rule and reduce your record-keeping obligations that way. Employers seeking to use big data analytics can't just adopt these procedures and set it and forget it. There are also legal risks to be considered.
That's right, Nathaniel. One of the first risks to consider is that many of the federal and state administrative agencies who are in this space are keenly aware of the increased use of data analytics and sourcing, and they're studying its impact on the statutory frameworks that they are authorized to enforce. One of these administrative agencies is the Federal Trade Commission. Another, of course, is the Equal Employment Opportunity Commission. And then, as Nathaniel just mentioned a moment ago, the Office of Federal Contract Compliance Program, or OFCCP, is very focused on the use and potential abuse of big data in hiring. What Nathaniel was referring to a moment ago when he talked about Internet applicants is defined in the Code of Federal Regulations. For those who are interested, it's 41 CFR Section 60-1.3. And I think Nathaniel's right. There's little doubt that the definition of Internet applicant includes those who apply for jobs through these digital hiring platforms. It's worth mentioning that in January of 2016, the Federal Trade Commission, or FTC, released its report entitled Big Data, a tool for inclusion or exclusion, understanding issues. I strongly encourage those who are in space to download a copy of it and review it. It's got a helpful information. Although the FTC is primarily focused on consumers, the report was written in conjunction with the EEOC, and it focused on a lot of concerns that the use of big data could have in employment decisions. For example, issues regarding the quality of the data, uncorrected biases in the underlying data, and the observation that whereas big data is highly effective in showing correlations, correlation is not the same thing as causation.
The thing to keep in mind is that the EEOC is increasingly focused on employers on claims of failure or refusal to hire, and one of the 6 enforcement priorities of the EEOC Strategic Enforcement Plan is to eliminate barriers in recruitment and hiring. And about years ago, the EEOC held a hearing on the use of big data analytics in hiring, and has been studying the issue ever since. So we have to keep a close eye on that. One of the important legal risks to keep in mind is whether by using a big data analytical tool, you'll trade the potential for a disparate treatment claim for one of disparate impact. there's no doubt that use of an algorithm is a quintessentially facially neutral process, but that algorithm might have an adverse impact on a group of people with a protected characteristics. For example, to take a very simple if you determine that software engineers living within 20 miles from the work location are less likely to leave their job, you seek to recruit engineers within 20 miles of your office. And the problem with that is if the office is located only in an area with predominantly white residents, the applicant pool will likely reflect an unintentional bias towards white applicants. Or similarly, if a algorithm is trained by using a data set comprised of current employees, all of whom happen, or the majority of whom happen to be male, you run into a situation in which the candidates that are being recruited or that are being interviewed and hired for the position skew towards being male, and because they're really representative of training set.
I think that's right. I think another issue is disparate impact, Nathaniel. In addition, is disparate treatment. If, for example, you've got a personality assessment that could be a prohibited medical exam or the ADA, or you could be asking questions that may or may not be about essential functions or that are job related that could trigger an ADA obligation. For example, do you belong to a gym? Right, you'd be asking that because there's a correlation between people belong to a gym and how long they stay employed. But if you ask that question in your digital platform, that may be unlawful because people who have a disability may not belong to a gym, but certainly that has nothing to do with the essential functions of the job. I think we're running a little short on time on our section, so maybe we can just jump to evaluating the products.
Definitely. Yeah, if you're considering using these products, the one thing, the overarching idea is to make sure you're in communication with your legal representatives. They should be reviewing contracts with any vendors for any employment law issues. And as a part of that, you should work with legal to conduct due diligence on each of these products. That's asking critical questions in terms of whether the algorithm has ever demonstrated an adverse impact with respect to other clients, getting an opportunity to utilize to run a training set or a pilot set on your own candidates. You should be asking whether the algorithm has ever been validated, whether it's been studied to establish the job relatedness of the algorithm to the job and for each job, and whether the validation evidence complies with the requirements of industry standards. In addition to that, you should make sure you have implemented proactive monitoring once you begin using that algorithm. These products are extremely efficient. That means you need to run an adverse impact analysis every time it's utilized and test it. You need to look to make sure that there are built data security protections. Ask the vendor how the data will be collected, how it will be stored, how it will interact with your system. And I think that point on data security protections made a good transition into Michelle's presentation on cybersecurity.
And very much, Adam and Nathaniel, for that very useful discussion. I do want to turn next to a discussion that gets to the intersection of data privacy and data security and its implication for employee benefit programs. And for that, I'm pleased to hand over to my partner and the co-leader of the TMT group, Capezza. Michelle.
Thank you, Ian. I'd like to take the next segment to discuss with you the need to focus on data privacy and security in the area of employer-provided benefits, and to remind you to ensure that your organizational cybersecurity plan takes into account. We all know that we are living in a digital world, and data is being gathered about each of us every time we log into our computers, smart devices, and the internet. We know that the risk for personal data theft and security breach is here, and we have seen many companies, notably cases including the Sony hack, Anthem breach, Equifax breach, and many which have followed, already having to respond to hackers who have stolen sensitive personal information, such as financial, medical, and other personally identifiable information from organizations. And they have had to undergo multi-million-dollar settlements for breaches. As organizations, employers have a duty to protect the personal sensitive information that they obtain from their employees. Failure to take preventive measures may result in legal claims, reduction in employee morale, and loss of reputation. With respect to employee benefits, the Alyssa Advisory Council has been studying this issue of privacy and security in conjunction with benefit plan administration for several years. They have been concerned about the security of the technological systems used in the benefit industry, their vulnerabilities to hacking, the potential misuse of the benefits data and the PII, and the impact on all parties. In 2016, they provided their most recent report to the Secretary of Labor regarding their recommendations for plan sponsors and fiduciaries to develop a cybersecurity strategy and program. Also, April 25th of this year, the Financial Services Information Sharing and Analysis Center, in partnership with the Spark Institute, announced the creation of the Retirement Industry Council to help out voluntary information sharing and threat intelligence to members within the industry that administer retirement plans such as 401ks, IRAs, and pension funds. One of the collaboration is to devise trusted best practices on security controls and priorities for the industry and protection of important retirement assets through information sharing of the cyber threats and vulnerabilities. As sponsors, and designated plan fiduciaries must also do their part to address data privacy with respect to their administration. There's no clear mandate regarding fiduciary responsibility under ERISA for cybersecurity of benefit plan data, but the developing consensus is that there is a definite duty, as with other fiduciary responsibilities, to accurately to be able to demonstrate the issues have been considered with regard to various processes involved in benefits administration, including collection, transmission, and storage of the data. That diligence has been undertaken with regard to service providers that they've been vetted, and their service agreements reflect this. Fiduciaries should be able to demonstrate, especially in the event of a breach or a lawsuit, that they acted prudently with care and with skill. So doing a benefit plan cybersecurity policy is evolving as a best practice. Just as fiduciaries may have an investment policy statement to guide their plan investment decisions, they should have a cybersecurity policy to guide one of the most important assets of their participants, their personal data. How do you go about doing this? Well, first consider getting the right people together to think this through and to develop a strategy. Identify the data you're collecting, accessing, transmitting, storing, etc. Consider where there may be vulnerabilities, risks. Consider what the applicable law is that governs the handling of this information and what may be required if there's a breach. You have to train your employees on these issues. You have to develop standards for selecting and monitoring the service providers and any tools or applications that are being used with respect to benefits. Due diligence. Ensure your service agreements address data privacy issues and breach notification procedures and indemnification and limitations of liability. And the participants. Getting cybersecurity insurance for the plans, and then adopt your policy, review it, maintain it, adopted by the employer's governing body, and if there's a fiduciary committee for the benefit plans under ERISA, the plan fiduciary should adopt it as a best practice document. Let's look at each of these in a little bit more detail. The right team. You may already have a team working on an organizational cybersecurity program, including information security controls, risk management, security policies. These will be your starting point for a deeper dive into how the employee data is being used internally and exported to service providers for benefit plans. So you may want to include your benefit plan committee members, IT, HR individuals, compliance, risk management, legal, and if you don't have all of these resources, then seek some outside assistance. Identify with your team the data and the risks. Know what you are collecting, accessing, transmitting, storing, vulnerabilities, what are the risks, and what is the applicable law. Types of personally identifiable information that is obtained from your employees for benefit plan administration. Names, addresses, dates and place of birth, social security numbers, mother's name, other financial information, all very sensitive. You should begin by auditing the information technology infrastructure and your network for security vulnerabilities. Any such audit should be done under the supervision of counsel to maintain the privilege and confidentiality of the audit. Based on audit, you can take steps to mitigate vulnerabilities found to a reasonable and appropriate level given the threats to the organization. One understanding of how to protect the information in your organization, you'll have to consider how to protect it once it is sent over to a service provider. Group plans have their own protocols, which you should have in place already for protected health information. That's really a subset area unto itself. If you have policies and procedures in compliance with HIPAA and high-tech requirements or appropriate business associate agreements in place, you will have to address this as well. And be aware that the legal requirements for protecting data and breach response are evolving. California was the first state to enact data breach legislation, 51 other states, territories, and the District of Columbia following, with variations of data breach legislation, and a complicated patchwork of data breach notification standards. There is a movement for a unified federal standard, especially concerning data privacy standards being adopted in Europe and elsewhere. In the EU, the General Data Protection Regulation took effect on May 25th and gives EU data subjects rights to breach notification within 72 hours of a breach and rights to be forgotten, meaning to have the companies controlling the data erase the personal information, among other rights. So employers processing EU employee data in the benefit plans for subjects to GDPR, you really need to consider if you are in compliance with this law and how to get into compliance. So these issues, the data itself within the organization, the data being outsourced to service providers, and the overall compliance with applicable laws, there are many, really need to be analyzed to ensure it's all being handled properly and that in the event of a breach, the employees, plan participants, and any government agencies will receive the right notifications and protection. Against cyber attacks, employers should also train their workforce on information security best practices. Know who is handling the data, ensure they are properly vetted and trustworthy, ensure they're following the protocols, educate them on how to recognize certain scams, ensure how to execute on a data breach response plan, that they're up to date on any organizational changes and policies, and they're deploying the same protections with the benefit plan. Employers also will have to be prepared to respond to a breach when it occurs. So employers formulate and implement a breach response plan to minimize the time from the discovery of the compromise to the reporting of the incident to the affected persons. And any employees involved in this chain of command will need to have open lines of communication and be able to adapt. With regard to developing standards for selecting and monitoring your service providers, any tools or applications, you establish your guidelines for engaging and renewing these service providers, such as confirmation of their cybersecurity program, any certifications, detail how they encrypt and protect data, their breach notification procedures, review of their service organization control reports regarding their privacy and security controls, level of insurance, and scope of their assumption of liability. Understand whether the service provider utilizes any agents or subcontractors to perform the services and the chain of those security measures. Work with your service providers to understand how data will be accessed by participants and third parties, such as online access or requests for retirement account distributions or transfers. If not already doing so, request that the service provider utilize enhanced measures such as 2- and even 3-step authentication for participants to access the information. Having service providers generate and issue complex usernames and passwords because participants frequently use the same passwords across different websites. Consider setting up alerts for any unusual behavior that's detected. If the service provider will provide apps or tools, such as those that allow plan participants to check account balances, contributions, investment changes, requesting loans or distributions, or tracking their own financial and physical wellness, and conveying such information to benefit plans, understand that the use of these mobile apps provide yet another opportunity for data breach or actual theft of assets and benefit payments. So that we should consider and set forth protocols that should be followed when introducing these apps into a program. And also establish rules for the IT security review of service provider systems, including a request for any periodic penetration tests to detect security risks. Address privacy and security, breach notification procedures, liability and indemnification provisions in service agreements in accordance with the standards of your policy. And consider how you will monitor that the security standards are being upheld on an ongoing basis. Updates to review any incidents which may have occurred, any changes to procedures, request annual audit reports and control reports. Form 5500 auditors will also ask record keepers for information on their cybersecurity policy. And to reiterate, document your due diligence, show that you've gone through important steps, any questions that you may have asked in a request for a proposal, retain plan records to show that you asked important questions and analyze the responses. As I mentioned earlier, review adherence to the standards, conduct audits, periodically discuss them at benefit plan committee meetings, have a record in your minutes that the plan fiduciaries have been looking at this as part of prudence and due diligence. And if you're giving training to employees, if you're educating participants, complete a record to show that you have been diligently addressing these issues. And agreements, again, make sure you're addressing them in your representations and warranties in your agreement. Confirm that any data breach notification policies that the service provider is promising are actually reflected in the agreement, or any sort of standalone policy is incorporated by reference. Review what limitations of liability may be in these agreements or indemnification provisions, and ensure that they're adequate in case there is a data breach. Consider who would be responsible for the cost of any notification in that regard, or any identity theft services that would have to be provided to participants, etc. You also want to address insurance issues. In addition to the service provider's insurance, employers should also consider that in addition to their own errors and omissions and fiduciary liability policies, that cybersecurity insurance has emerged in recent years and can offer various types of coverage, including coverage that would allow a benefit plan to trigger coverage upon a breach for certain disaster recovery and response assistance. But evolving. Recently, Warren Buffett said he doesn't want Berkshire Hathaway being a leader on underwriting cyber insurance because it's difficult to quantify the risk. Yeah, the cyber risk in general carries about a 2% chance of a super catastrophe that could cause $400 billion or more of insured losses. So obviously it'll be important to evaluate the insurers that are out there and able to underwrite this type of insurance and how it may provide additional protection to other policies. So you should assess your service provider's level of insurance and also what you can do on your side as an employer and plan sponsor to implement these levels of insurance. And obviously have your agreement reviewed by IT and that all of the issues are properly addressed. You're also educating your participants. Plans educate their participants on a myriad of issues, financial information. They're looking for education on investments, looking for information on wellness. Next, information on data privacy and security. Remind your employees regarding the importance of safeguarding their data at all times. When scams, how to recognize email scams and phishing scams. And use of passwords with a high level of security that are regularly updated. Advise them to safeguard and monitor their own accounts, not changing accounts in hotel lobbies or public libraries. Employees to avoid posting too much personal information as well, because people can connect the dots of certain information to give that a bigger picture of personally identifiable information. Finally, what you need to do is the policy. After you have gone through all of your thought process and chaos of what you need to address, adopt the policy. As I mentioned earlier, this may be adopted by the employer's governing body as a plan sponsor document, but the plan fiduciaries want to show that they have addressed this as a best practice and have adopted a prudent fiduciary best practice policy. Remember to go periodic reviews as the laws change and technology changes, that it's being updated by your team that you assembled of experts up front. Make sure that it's being brought up to date. Continue to review audit reports, especially of your service providers, to see if they've had any incidents or things that need to be addressed. Any upgrades, keep in lines of communication. Make sure you don't have outdated service agreements that have never even been updated to include the latest and greatest language from your service providers on data privacy, security, and breach notification. And remember, check your apps and new technology that you're bringing into the benefit plan offering. If a data breach does occur, you'll need to immediately execute a data breach response plan, quickly investigate the nature and scope. You may need a forensic review by IT that can trace the origins of the breach. Employees and anyone affected would need to be notified so they can take steps to prevent or limit identity theft and other damages. You may need to notify the police to work with a local cyber crimes unit. You may have to file a civil suit against the perpetrators to obtain injunctive relief and reduce further damage. You may need legal counsel. So as you can see, this is very serious, and your policy must be treated as a living document. It will need attention and updating as the landscape evolves. The time is definitely now to develop a prudent policy, can anticipate all of these issues, for a streamlined approach to correcting any problems, and ensure that the plan participants feel secure and that their plan data and their assets will not be compromised.
Thank you, Michelle. And last but certainly not least, we want to turn to an issue that's particularly top of mind to many employers and many of our clients, particularly in the wake of recent legislative changes in California and Delaware, Maryland, Massachusetts, New York, and Oregon, and that is pay equity, the issue of pay equity in the workplace and the result in pay equity audits. And it's certainly an undertaking that we've been called upon to conduct for many of our clients as of late. And so for this discussion, I'm very pleased to hand over to my colleagues, Nancy Gunzenhauser-Popper and Alyssa Muñoz.
Thanks so much, Ian. Good to talk to you about pay equity audits today and really the impact that big data is having on an employer's ability to conduct these audits. And what we're going to go through in this last segment that we're talking about today are really the basics of conducting an audit. So what to conduct one, how it is done, when it should be done, who should be performing this audit, and what exactly the audit should contain. So first we're going to think about why employers are conducting pay equity audits. And as Ian noted, there's been a host of legislation that's come out in the past couple of years, and even more since we've seen this Me Too movement pursuing the idea of equity in the workplace. And these states and cities have come out with a variety of laws that are incredibly different from one another and different from what we've seen under the federal law with respect to equal pay. And it will impact how employers will perform the audits, what the goals are, and how they should be performed. As mentioned, within California, Maryland, and New Jersey most recently, one of the big things that we've seen with respect to pay equity laws is that we're just seeing that claims can be made because men and women are being paid differently. We're actually seeing a broader scope of these laws. So someone can bring a claim that they're being paid differently based on other protected categories. In California, that's based on race or ethnicity. Maryland protects differences in pay on the basis of gender identity and expression. In Jersey, which was just signed in the past month, every single protected class in New Jersey is covered under the pay equity statute, meaning that for any of the variety of purposes, employers cannot pay people differently unless there is a legitimate business reason for doing so. With that, we're also seeing legislation coming out regarding pay transparency, which makes it in the workplace that employees can speak with one another about what they're earning. That's made it a much hotter topic in the workplace and a reason that employers are choosing to conduct pay equity audits in order to ensure that there's fairness among pay and legitimate reasons for doing so. We're seeing in many locations, including New York City, California, Connecticut just passed a law about salary history inquiry bans. So what these laws are saying is that employers can't ask what an employee makes at their current or previous jobs in order to determine salary when they're coming into a new role. And the historical context is that if a woman was being paid less at her previous job and his new salary is based on that, it's just perpetuating the inequity between pay at a new company. So the idea is you ask, you just think of a new salary based on what's going on in the market and how someone prices a role. Of course, it's not always that easy, and certainly when coming into a new role, you do consider a variety of factors. That's one of the increasing reasons that employers are considering conducting pay equity audits. The thing that we'll note is in Massachusetts, the law is coming out in just a month, July 1st of this year. Employers who do conduct pay equity audits will have a safe harbor defense that you, in good faith, engage in a pay equity audit to try and resolve these inequities. An employer has a defense if there is some sort of claim. So one thing to consider. Now, all of these other locations, there's no such safe harbor. So something to think about based on the geographic location of your employees. And one reason that employers are conducting these audits is, you know, it's good publicity when employers are taking steps to try and resolve inequity in the workplace and create a more fair environment. So with that, we're going to turn over into some of the other elements of who, when, and how of these audits.
Thanks, Nancy. So in the moving pieces related to pay equity audits, what objectives when conducting a pay equity audit? The first is to identify whether pay inequity exists that cannot be determined by legitimate neutral factors. The second goal is to determine whether the policies that an employer has in place are creating or contributing to these disparities. Perhaps hiring procedures in place that contribute to pay inequity. For example, a company might have a no salary negotiation policy at the time of hire. On the flip side, the company policy might permit salary negotiations. These scenarios can be a contributing factor to pay discrepancies. How about acquisitions? Has your organization recently gone through an acquisition or a reorganization or implemented a new technology? And if some employers run into an acquisition or a major reorg, is that acquired employees are integrated into the company as is, so to speak, regarding their titles and salary, would not be in line with the company's other employees. Going through a pay equity audit, it's helpful to think of the life cycle of your employees as well as what's going on in your company more broadly. So to understood the objectives, the next step is really identifying the scope. First and foremost, before doing a pay equity audit, you have to know that if you're going to do it, you're going to have to act upon the results. The worst thing that can happen is you undergo a pay audit, you find out that there are disparities, you get a sheet of paper that says, here's who's being treated differently, and then do nothing with it. That's just the thing going into it, because that'll be Exhibit A to the eventual claim that comes down. So make sure before beginning an audit that all of the appropriate stakeholders are on the same page with what's going to happen in terms of how to conduct the audit and what will happen afterwards. We talked about before, where you are located will really guide how you're going to do this audit. So based on where the employees are located, different laws about inequities in different ways. New York State, the equity law says that employees can be considered based in the same county area. While think about, someone who is in Manhattan is going to perhaps have different salary than someone who's in Albany. And we think about that there are different cost of living issues, and that can be taken into account when considering pay. We think about California's pay equity law. It considers all employees across the U.S., so it doesn't care where people are located. So that's a really important thing to think about when you're deciding which employees are we going to look at and which laws will apply. We also want to consider who are we comparing. Is it everyone who is at a certain title? Is it everyone within a certain department? Is it everyone, based on their location? So those will all be factors that go into deciding who is a comparator to see what the differences in pay are. One other important piece, as we talked about, is who are we comparing? Are we comparing men versus women? Are we going to decide to compare it based on other protected categories? Now, most employers who undergo a pay equity audit will first start out with comparing men and women. That is the most hotly contested area when it comes to pay equity. But given these new state laws, there may be other things to consider. Important thing, we always do recommend that if a pay equity audit is undertaken, that it is in conjunction with an attorney to help preserve attorney-client privilege and work product. Because again, you'll have that report or that sheet of paper, and you want to make sure that you got that guidance and protection when undergoing the audit.
So if you're discussing the scope of the audit, what resources are needed? Here, employer stored data is your friend, and the more information you have regarding your workforce, the better. It's helpful to ask on what systems is the data regarding the demographics of your workforce located. This can inform employers of where women, minority, and older workers are located in the organization. Also, ask who manages this information. This may be your HRIS team, compensating partners, perhaps a combination of both or others. However, if at this point you recognize there's a group or stakeholder missing from those initially identified when discussing the scope of the audit, be sure you're included going forward. Again, the scope of pay equity audit, it's an ongoing conversation, and it may morph throughout the process. It's also important to pull together any current procedures or policies on activities that drive or affect an employee's compensation. For example, performance evaluation procedures, job descriptions, any training programs that contribute to base compensation and pay increases will be helpful to your analysis. Part of the departments in scope has a clear career trajectory and therefore an established promotional path. Considerations such as what is that path, who makes those decisions, what is required of employees when going through that process. Also consider what information HR has in its records. When making compensation decisions, informal discussions and performance feedback may be with HR rather than the employee's managers. However, if information is not readily available, we also recommend reaching out to the managers directly to gather information on how they determine pay changes and what factors they may look at when doing so.
All that data gathered, what we typically recommend is that you use a statistician to help perform the analysis. One of the reasons that it's helpful to do that, particularly through counsel, is that the information can come back to you and your attorneys, and then you can consider what next steps to take. Often the way the statistical analysis will work is you'll decide whether the comparison is, which factors will be compared, as we talked about, and it'll separate out the individuals into two different categories to determine if there's any sort of statistically significant differences among the pay in certain groups who are equally being compared. Based on the review of all of this information, you'll consider whether the procedures that Alyssa was talking about, the ideas of promotion guidelines and other procedures, are being applied consistently, or if they are not.
Reading what Nancy just mentioned, this next step of the audit will largely be determined by the statistical analysis and findings from the previous review or the initial review. Here, employers will want to conduct an additional review for any employees or job positions that showed pay discrepancies or potential discrepancies during that side-by-side analysis. If there are employees or specific positions affected, then this subsequent review is where you'll want to consider neutral factors causing or contributing to the pay discrepancies. Is it due to length of service, education level, location, etc.? We touched on this earlier in the presentation, but also consider what's going on in the company more broadly. What changes have occurred within the organization or the business? For example, is your technology organization showing pay discrepancies? Have there been recent or major internal reorganizations? Perhaps recently phased out a legacy platform or combined two different teams of software engineers. there have been recent layoffs, and the folks that remain are in the process of transitioning to new responsibilities. Relates to acquisitions, cleaning up and integrating job grades may have been a phase 2 exercise that has not yet happened. Anticipate at this stage that there may be unexpected errors or disparities that surface in your analysis as well as during your subsequent review. All this to say, remain flexible. Round 1 and 2 of diving into the data may require a round 3 and 4 to properly audit and identify the underlying factors that are contributing to pay inequity.
So we know what the analysis says. There's the next step, and that is taking some sort of remedial action. The important part, and again, this is important to get everyone on board before the audit begins, is that employers need to be prepared to take action to address the pay disparities that are not otherwise addressed by, those neutral factors like length of service or level of experience. So certain employees will need to have their salary increased. And we don't recommend bring someone down. The right way to go is to bring people up. And it's really important to figure out the best way to communicate this to employees, because this can be something that can trigger employees wondering, why was I not paid the same way in the past? So incredibly important to decide whether, it's going to be rolled out at the same time that regular salary increases or bonuses are being made. It is going to be at the beginning of a calendar year as a fresh start. Will this be part of some other ongoing legislative action? So many states have increases in requirements for salary basis thresholds or in order to meet exemptions. So as part of those communications, this could be something to roll into that. But it's incredibly important to make sure that the communication piece is right to help mitigate risk of other complaints.
Right, did the audit, and you've started taking those remedial actions. What are best practices going forward to avoid finding yourself in a similar situation? Well, we recommend remain compliant, number 1, with all laws that apply to your business. Stay up of the changes to state laws, specifically those regarding salary history ban legislation and pay transparency requirements. Review job descriptions and job grades, especially for positions or departments that have seen a lot of movement or changes recently. For positions, there may be a natural career path. Take advantage and consider implementing standard pay ranges or guidelines. Also, take the opportunity to review and update your existing performance management processes so that it is consistent across departments, specifically regarding those with comparable work. Also, a great time to review hiring practices and train management, HR, recruiters, and compensation partners as needed. It's important going forward. Any of these processes or procedures were identified in the audit as contributing to pay discrepancies. Most importantly, and if nothing else from this presentation sticks with you, remember, if you conduct a pay equity audit and you uncover that discrepancies do exist, fix them. Remember to fix them.
Thanks so much. Very, very useful. I mean, certainly at the firm, we're of the view that pay equity is going to continue to be a critical issue for all organizations moving forward. And it's also going to be an issue that gets more and more attention in the media and by the general public. So please continue to watch this space. I think we have some time for questions. So if you want to submit questions through the WebEx portal, feel free to do so now. I know we have at least one question pending right now, which I'll address, or I'll read aloud and I'll open it up to the group. So the question is big data, or the actions based on the data set from data, the same as AI or artificial intelligence, or a subset of it? If not, what is the difference? So what is the relationship between AI and big data? Maybe Nathaniel or Adam, you want to take that. Please unmute yourself.
Yeah, do you want to jump and I'll add?
I would say that based on the way that these terms are used, are currently being used, I think often big data is considered sort of an umbrella term, and AI would fall as a subset of that. So data analytics may involve some unsophisticated data mining, but it could also be or include machine learning and AI. And so the risks with using any big data analytical tool are similar, but if your algorithm constitutes, if AI, if it learns, then you need to be aware that changes based on newly acquired data, you, neither you nor the vendor or the data scientist that created that algorithm may be able to figure out exactly how the algorithm is working once it gets going. And so that creates problems. It could create problems in litigation if you have to produce information related to how the algorithm is working. Something to keep in mind.
Yeah, I think that's right. The only other point I would add to that is piggybacking what Nathaniel said in terms of best practices going forward and the issue with monitoring. When you roll out this new technology, whether it's a hiring platform or some other machine learning or AI that you're using for workplace issues, it's important to always assessing the results you get early and often to make sure there's no issues. So as we just heard in the last segment, you course correct and fix. When you are talking about AI and it is learning and it's changing what it's doing based on the data that's coming in and the input then changes, that tells you that your duty to monitor and course correct if things start going sideways is even more important.
Yeah, one of the things that we've recommended successfully in the past is that if you have the time and budget to do so, to implement the tool on a pilot or test basis, so that you won't actually be using the results, but you test them on an initial go round, and then once you do actually put it into use, that yes, you stress test it and monitor early and often, as Adam said.
Thanks very much. We don't seem to have any further questions in the queue, so I think we'll wrap and give everybody 3 minutes back of their day. This concludes our webinar. Please be on the lookout for a communication from our firm about how to get access to the PowerPoint and the recording of this webinar. Our next webinar is on Wednesday, June 27th, which will be hosted by the HEAL Committee, Health, Employment, and Labor Committee. So that'll be Wednesday, June 27th. And if you have any questions, feel free to follow up with any or all of us from the panel and from the firm or from your relationship partner here at the firm. So thank you very much for joining us.